Good morning, friends. Today's topic is master and servant relationship, vicarious liability. This comes under the subject thoughts. My name is K. Umesh Rao. I am requesting you to subscribe my channel and it will motivate me to give more and more speeches. Now, we have to discuss who is master, who is servant, and under what principle this theory of vicarious liability developed, and what is all the exceptions. The master and servant relationship. Before that, we have to discuss what is vicarious liability. Usually, man is liable for his own wrongful acts. If I have committed a mistake, then I am responsible. But he is not liable for the wrongful acts of another. But under certain circumstances, man may be held for liable for the wrongful acts of another. This is called vicarious liability. Master is vicariously liable for the tortious act done by the servant in the course of employment. Like this, liability of the principal for the torts of his agents. Like this, liability of the partners for each other's task. Liability of the master for the torts of his servants. All these are coming under vicarious liability. Essential elements here. Tortious act must be committed by the servant. The act must be committed in the course of employment. So, master and servant relationship, there are two essentials. One, act must have committed by the servant, and it must be committed in the course of the employment. Now, who is master? Who is servant? Servant is one who is under the control of another. Servant is an agent. The servant is under the control and supervision of the employer. Employer pays wages to servants. The employer can question his servant. The employer can suspend or dismiss his servant. For the torts committed by servant, employer is liable. Who is master? Master has power of selection of his servant. Master pays wages. Master controls the method of work. Master can suspend or dismiss his servant. Master has ownership of tools. Master gets profit or loss. Now the principles. Why the master is held liable for the act of the servant? Why? And what is the principle under which this theory developed? First one, he who does an act through another is deemed in law as acting himself. Here, servant, he does an act for his master, and master is doing an act through his servant. It is deemed by law as is acting himself. Because master is in a better position to meet the claim of the injured person. Because master has a larger pocket. He is respondent superior. He can possess the liability of the insurance company. Hence, master is liable. Now, master liability to the wrongful acts of the servant. Servant is like slave. Servant is like agent. He is acting in the course of employment. Now, employer liability. And when employer is liable and when employer is not liable, this question comes. Employer is not liable for an act done in unauthorized mode of doing authorized work. Master is liable to third persons for any injury or damage done through the negligence or unskillfulness of the servant acting in his master's employment. But see, employer is not liable for act done in unauthorized mode, but master is liable for wrongful act, but unauthorized mode of doing authorized act. it is a wrongful act he has done. For example, government jeep was driven by a clerk. It was driven by a clerk with the permission of the driver. Driver had consumed liquor. While driving, clerk met with an accident. It is held that government was vicariously liable because it was a wrongful act done by the clerk. Servant is not acting within the course of employment and doing for himself at the time of accident caused. Then the master is not liable. What is the meaning of in the course of employment? Owner gives the car to the driver. Driver gave the car to the cleaner for taking driving test to RTO office. While driving by the cleaner, accident happened. Driver was not in a vehicle at that time. It was held that act of the cleaner was beyond the scope of the employment. Master is not held liable because the accident happened when the car was not using for master's business. Another case, Lloyd versus Grace Smith Company. Lloyd was the owner of 2 cottages. She approached her lawyer to dispose them as she is not satisfied with her income. The clerk of the defendant company approached her at her residence and obtained her signature saying that these documents were sale deeds. In good faith, she signed on those papers. But these papers were not sale deed but gift papers. The clerk sold the cottages and misappropriated the money. The lawyer sued the defendant for damages. House of Lords held that clerk acted solely for his personal benefit without the knowledge of the principal. But he did the fraud during the employment, in the course of employment. Hence, master was held liable. Another case, Morris versus C.W. Martin and Sons. Plaintiff gave 4 coats to cleaning for defendants. The defendant company handed over the coat to the employee. Employee stole the coat. Court held that defendant company is liable for the theft of the employee. Coats are stolen during the employment and in the course of employment. Another case, Barley versus Manchester, Sheffield and Lincolnshire Railway. Railway company appointed certain persons to facilitate the passengers to get their correct train. Plaintiff purchased a ticket and sat in a correct train. Employee mistaken and asked him to come down. Plaintiff refused to come down. Employee pulled him and he received injuries. House of Lords held that it was a mistake of the employee against the plaintiff and it is in the course of the employment and defendant company is liable. Cases done beyond the scope of the act but implied authority given. Acts done within the employer's authority. Here obviously it is in the course of employment. In this case, owner of the car ordered the servant to take care and take this car directly to garage. But the servant taken different route to do some private work. While driving, he caused accident and caused damage to the car. Master is held liable because his servant was under the authority of the master, though he has taken a different route. Another point is, a servant while going to the place of work or returning there from acts in the course, it is in the course of employment. Servant is traveling in employer's time and journey back was in the course of employment, and if anything happened to servant or what he has done, act done by the servant, employer is held liable. Next one, acts done within the implied authority or obviously in the course of employment. Manager of the company was driving a car of the company on its journey from Nagpur to Pandurana. Travel is related to company's business. Manager took one person named Purushottam as a passenger in the car. The car met with an accident due to the negligence of the manager. High Court dismissed the case of the defendant on the ground that manager was not acting in the course of employment. Defendants approached the Supreme Court. Supreme Court reversed the decision of the High Court and held that Manager, being responsible person of the company, he permitted Purushottam in the car. It is presumed that manager had the authority to carry Purushottam and he was acting in the course of employment. And dishonest and criminal act of the servant, master is not liable for a dishonest or criminal act of the servant where the servant commits wrongful acts. Example, window cleaner steals the article from the room in which he is cleaning. It is held that master is not liable. Another, master is not liable for the torts committed by the servant whose appointment is compulsory under the law and the master has no power of selection. Next one, master is not responsible for the negligent harm done by one of his servants to a fellow servant engaged in the common employment with the master. So, another last one, vicarious liability of a master for his independent contractor for tortious act. What is that? Who is independent contractor? He is exercising an independent employment. He contracts to do a piecework. He is working according to his own method. He is not subject to his employer's control. For the torts done by the independent contractor, whether employer is liable, employer is not liable. The master cannot suspend or dismiss the independent contractor unless he violates the terms of the contract. What is the difference between independent contract and servant? Servant is a person who works for another salary, but independent contractor is not working for salary. For example, A is the car owner, B is the driver. A gives salary, so B is servant. In other case, A wants to go to railway station. A contacts B, an auto driver. A pays the amount as per the meter reading. In this case, B is the independent contractor. B is not a servant. So, case law, Morgan versus Incorporated Central Council. The company had entrusted the management of lift facility to the independent contractor. The plaintiff fell down from open lift and got injured. Plaintiff sued the company. The House of Lords held that the defendant was not liable and the plaintiff had to sue the independent contractor, not the company. Another case, owner of the lorry entrusted it to a garage for getting it repaired. Lorry was in the custody of the repairer. One of the employee of the repairer drove the lorry and caused an accident by driving lorry negligently. The injured party sued the owner of the compensation. Injured party sued the owner for compensation. The High Court held that owner of the lorry was not liable because lorry was entrusted to an independent contractor to get it repaired. Repairer of the lorry was held responsible. The principle of respondent superior does not apply in the case of employer and independent contractor. But there are exceptions. Sometimes, though independent contractor commits wrong, employer will be liable. The general rule is that master is held liable under respondent superior for his servant's tortious act. He is not liable for the independent contractor tortious act. But under certain circumstances, master is held responsible for independent contractor's tortious act. This is called exception to as detailed below. If the master authorizes to do an illegal act or master ratifies or approves the illegal act done by the independent contractor, master is held liable. Second, the rule of strict liability applied to the master even in case of an independent contractor doing certain work for his master. Third, the rule of absolute liability principle is applicable to the master even if independent contractor does certain work for master. Fourth, as per polluter pay principle, The industrialist or occupier should pay the compensation to the victims. He cannot escape taking the pretext of independent contractors. Fifth, the master who possesses properties near the highway has more liability, and due care has to take tortious act caused to the users of highway by his property. Employer is liable for the breach of duty in case of negligent in selecting the proper person. Employer is personally liable. Employer is liable for failure to take necessary steps to avoid the risk which he authorized to independent contractor. When the employer personally interferes and retains his control over the contractor and personally interferes and makes himself a party to the act in which damage occurred, master is liable. Employee is authorized to do an illegal act, work likely to cause danger, he is liable. Man employs a contractor to build a house as to darken the neighbor's window, then owner is liable. If the work itself by nature caused danger to others, it was held that employer is liable because there is a duty on the part of the employer to take all reasonable precautions to avoid such danger. Thank you.